Y'all, good morning, and welcome to the House of Dreams seminar. My name is Taylor Stair. I'm an attorney with Parker Poe down in Charleston. And with me here today, we've got Ann Derbyshire with 210 and Charles Foster with Southeastern Insurance Consultants. And for those who are in the industry, those two need absolutely no introduction, but Ann is the go-to when it comes to warranties. Home warranties, she can talk about internal, but most importantly about third-party warranties through 210. Charles is your go-to when it comes to talking about insurance policies, whether it's general liability, additional insured, or whatever policies you need for your business. We all remember Field of Dreams, and I know that because I can see the age in this room. When I talk to my associates in their 20s, most of them had never seen the movie. But Field of Dreams is one of my favorite movies, and I thought there was this great parallel between that movie and what we deal with in the home building industry. Y'all recall Kevin Costner buys this farm, he's out in the fields, and he hears this voice. And what's that voice say? Somebody.
If you build it, they will come.
That's right. And what's he talking about? They're talking about Shoeless Joe Jackson and his buddies. And sure enough, Kevin Costner builds this fantastic baseball field, right? And then Shoeless Joe and his buddies come on out of that cornfields. And as I was preparing this seminar a year or so ago, I thought about that correlation, and it's true, right? But in the home building industry, if you build it, claims will come. It's inevitable, and it's unfortunate, but it's a fact of life. Whether it's dealing with punch list claims at the end of construction, whether it's dealing with warranty claims after construction, whether it's dealing with LLR claims or formal lawsuits, you will inevitably be faced with some type of claim. And so what we're here today to talk about is strategies for dealing with those claims and protecting you, whether it's through contracts, warranties, or insurance. Now, I mentioned that Ann and Charles are known in this industry. I'm not. I'm kind of riding their coattails, so I wanted to give you a little bit of background about who I am so you can understand where my advice and recommendations are coming from. I graduated from law school in 2008 during the Great Recession, right? So it was a terrible time to graduate. The economy was in the tanks, but one thing that wasn't was lawsuits against builders. And so if you look over here in December of 2008, that's when I graduated, and it is at the very bottom of the housing industry, right? It was a terrible time for builders. And I say that because I wouldn't be in construction but for the Great Recession. So I graduated from law school, I did fairly well, had a great resume, but it didn't matter. There was nobody hiring. I sent out 40 resumes, and I got 35 rejections, and 5 people just didn't even respond. So I got called for jury duty, and it was a 2-week-long construction case against a builder and all their subcontractors for a multifamily project. And during jury qualification, you have to stand up, and there were 300 jurors, and I was juror 254, and you had to stand up, and it's name, age, occupation. And I'm looking, there's like 50 or 60 lawyers out there, all for this one case, right? Construction case. So I decided to shoot my shot, and I say, hey, I'm Taylor Stair, I'm 27, I just graduated from law school and I'm looking for a job. And the place starts laughing, and so the clerk says, well, juror 254, can you give him your last occupation? I said, well, yeah. So I give him my resume. I talk about every law firm that I'd worked for and every judge that I'd clerked with. And I got 3 interviews out of that pitch and 1 job offer that week. And I took it because it was the only job offer that I got. But it was in construction litigation, and I've been doing construction ever since. And I tell you that because I am an example of the correlation between a downturn in the economy and an increase in claims against builders. That's the reason that I have my job, and I've been doing it ever since. So for the first 8 years of my practice, I represented subcontractors. First 5 years of my practice, I represented subcontractors, whether it was a roofer, framer, stucco applicator, foundation, plumber, electrician. I did it all. And that's how I learned the business. And then I represented a home builder in 2012 with Ron Tate, and it was a case in Columbia. And that changed everything for me. And ever since then, I've been working with home builders. So that's to give you a little bit of a background of who I am and where my recommendations are coming from. But I wanted to show you something that's really important. We went through the cases that have been filed against builders over the last 6 years. And I want to show you these trends, and we're going to go back and kind of go through more in detail, and we'll talk about it. But before COVID, I like to talk about before, during, and then after COVID, because you'll see why. But before COVID, we were averaging about 70 claims against builders per year. Formal lawsuits that were being filed in court. And what this chart does not show you are claims that are being filed or initiated in arbitration, right? Because that's private, and we'll talk about that in a minute. But you can see it's a dramatic increase. I mean, we're talking about more than 3 times the number of lawsuits are being filed against builders today than they were 6 years ago. And we're going to talk about why. We're going to go back to 2020 though, because this is when times got really weird, right? You had people wearing trash bags to the grocery store. You had people wearing, pool noodles to keep social distancing. And I know we remember this because this is in fact true, where we had social distance events where we would sit in our driveways and talk to people 10, 15 feet apart because we were so concerned about this virus back then. We had no idea. But how did that affect construction? How did that then ultimately affect the claims against builders? Well, in 2020 and 2021, what were we doing? We were sitting at home all day, every day, right? And so what these homeowners are doing is they're seeing these conditions in their home. They're saying, oh, I've got cracks in my drywall. They may not have noticed them before, but they're looking at it all day, every day. It becomes this obsession. Cracks in the foundation, squeaky floors. All these issues start to become more and more problematic. So what do? They submit warranty claims to their builder and they say, hey, I need you to come fix this. They may not have done it before, but more and more homeowners were doing this. And so our warranty departments were completely stretched because of the massive volume of claims that they were getting. So many of those warranty claims were getting addressed, but many others weren't. It doesn't mean that they were all covered, so that would explain some of it, but in reality, it's because the builders didn't have the ability to address all those warranty claims. So that's with existing homes. Let's also talk about new construction. Remember 2020 and 2021, what were we dealing with? A labor shortage, right? A massive labor shortage, and we're still dealing with that today. I think the last number I saw from the NAHB is like 750,000 nationwide that we're down. I mean, listen, to me, this is critical because not only was there a labor shortage, so skilled trades, right, who may not know what they're doing, were building homes. There also had material shortages. Remember, not only framing, right, steel. I had builders who didn't have enough paint. They could not paint the interiors or exteriors of their homes. So that again delayed construction. So there was a number of issues that we were dealing with that negatively affected the quality of the products that we were putting into the market. And this isn't true for every builder, I get that, but we're talking about generalities and trends, and without a doubt, the warranty issue and the shortage in labor and materials led to where we are today. Now, in 2018 and 2019, this is pre-COVID, and this is consistent with what we were seeing before, all the way back to 2015, but I didn't want to go through and give you too much data. But it's about 70 cases filed a year. That's one every 6.5 days, so basically once a week, right, before COVID. What happened during COVID? You see that number actually dropped. That's kind of surprising, right? You think, oh, the downturn in the economy, everyone's freaking out, they're going to shoot the numbers up. Well, the problem is the courts were closed for a long time. There was less access, right? So we're averaging about 60 per year. Well, then what happens once life returns to normal? It skyrockets, right? Last year we had 120, which is double the number of claims that were being filed annually. This year we're over 200. It is an incredible pace that we're seeing. That's one every 2 days. So I'll tell you, I get an email every day that shows us every lawsuit that is filed in the state of South Carolina, whether it's a personal injury, whether it's a construction defect, employment related, and one every 2 days, we're seeing construction defect lawsuits filed against builders. So the question is, what can we do to help builders, right? What can those who work in contracts, insurance, and warranties do for y'all? The first thing is, we need to take a look in the mirror. And this is truly what the builders can do for themselves. You got to build a quality home. Make sure that you have the proper management and staff and supervision of your trades on site, right? We want to make sure that we've properly staffed ourselves to build that product that we're all proud of. We also need to communicate well with our trades and with our owners. Now, communication is critical because it sets expectations. I always say to my clients, look, I want what you say, I want what you tell your trades or your clients in writing. People say, well, that could come back to bite me. Sure. But listen, if you tell a homeowner that you're going to do something, you need to stand behind it and do it. If you tell a trade, I expect you to do this, well, guess what? They should do that. So if you're afraid to put it into writing because you're afraid of what may happen, you may need to second guess whether or not that's the route that you want to take. So communicate well, right? And service your clients. And your clients now, I'm specifically talking about the owners, those you are selling homes to. If they submit a warranty claim, be responsive. Treat them like you would want to be treated, right? It's that golden rule. I don't mean make all the repairs that they ask for, not at all. But tell them why you're not going to make them. Hey, listen, under this section of the warranty, we're not obligated to do so. And we're going to talk about situations where you still may want to perform repairs, but make sure whatever you do, you're responsive. Don't let your owners sit in the dark, because that's when they start to get frustrated with builders. All right, now we'll get into the things that we can help you with. Contracts. I was thinking about the game Battleship, which I cannot believe Ann has never played in her life, but this was one of my favorite games growing up, and my kids and I still play this today. And the more I think about it, I don't ever really use the same strategy, right, when I play Battleship. There's never one size fits all, and that's the same with contracts, right? The way that you run your business isn't the same way that you run your business. And every builder has different wants and needs, right? You have different issues with how you want to get paid, when you want to get paid, how you deal with your trades, how you deal with your clients, claims. These are all important things that you need to consider. And the good news is you got options. And what I'm going to talk to you today about are big picture strategies, and I would highly recommend that you visit Ron Tate's presentation this afternoon, because he's going to get into the weeds and talk about contracts and certain provisions that will help you as builders protect yourselves. What I like to do when I talk with my clients is talk big picture. At the end of the day, where do you want to be? If a formal claim is filed, and then we're going to work down. But where do you want to be? Do you want to be in court, which is a public forum, or do you want to be behind closed doors in arbitration? Now, there's pros and cons to each. Now, if we're in court, right, you've got a number of options. You could demand a bench trial, a non-jury trial, or you could say, hey, you know what? I'd rather be in front of my peers. But then I would ask that question, do you really believe that those potential jurors are really your peers? Are they builders and contractors who are going to be sympathetic to you? Or are they going to be more empathetic to those homeowners who have issues with their homes? And I will tell you, it depends on the circuit. So it depends on where you are in the state. So you need to know where you're building, right? And that's going to be the same for judges, although we do have judges that travel. But for the most part, there are judges assigned to certain circuits. And so you will have different judges and jurors depending on where you build. So you need to have that discussion with your attorney to say, hey, what do you think? If I'm in Horry County, what would you recommend? If I'm in Jasper, if I'm in Richland, if I'm in Greenville, what would you recommend? And so that way you know at the end of the day where you want to be, whether it's in court, whether it's with a jury or a judge. But there's also another option. That's arbitration. And arbitration is, a really hot topic right now in the home building industry. But I want to make sure we understand, I read a lot of contracts from builders that always demand AAA. And I say, do you know what that really means when you demand AAA? Yes, it is a very popular and common form, but it can be incredibly expensive depending on that threshold. So it depends on which construction rules apply, but generally speaking, if the claim is over $1 million, that requires a panel of arbitrators. That's 3 attorneys who are going to sit there, it could be engineers as well, charging you $500 an hour for every call, every hearing, the trial, if it's a week or 2 week long trial. Costs add up. That being said, if you tender to your general liability carrier and they pick up your defense and they're agreeable to paying for those fees, well then it's no harm, no foul to you. And then it's actually a benefit and maybe a deterrent to the owners who don't want to incur those costs. So look at it from that perspective. Okay, well maybe AAA would be good because it may deter some. I've also used it to leverage claims against builders where we say, hey, I know that this requires AAA and a panel of arbitrators, but if you agree to limit your damages to $1 million, or you agree not to pursue punitive damages against my client, or there's all these options that you can do to get them to agree to a private arbitration. That way, you can pick the arbitrator, and then your costs go from 3 arbitrators down to 1, and you've hand selected. Because my second point is, you don't know what kind of panel you're going to get when you file a claim with a AAA. They'll give you 5 or 10 potential arbitrators, and then you work with opposing counsel to figure out, okay, who do you ultimately want to use? But I say that because even with arbitration, there are many different options that you've got to choose from. So that's at the very top, right? Where you're going to end up. Is it litigation or is it arbitration? Well, before that, there's a method to prevent claims from becoming formal lawsuits against you, and that's pre-suit mediation. Now, a lot of times you'll hear, oh, that's just a delay tactic, and maybe it is by some, but in reality, if a lawyer is going to file a lawsuit against your client or you, they're going to agree to mediate. So I don't look at it as a delay tactic at all. In fact, I think it's a great opportunity to resolve claims against you using your trades. Now, we will talk about this in a little bit, but it's critical that you have strong contracts with your trades, because if you do, you can require them to attend the mediation. And for most builders, we're not actually lifting any hammers, we're not striking any nails, we're letting the trades do 100% of the work. So if there's a claim against us for faulty framing or roofing, listen, as the builder, we shouldn't be held solely responsible. It's the people who actually perform the work. So get them to come to mediation and resolve those claims. And I've noticed this has been a very successful trend recently. So I would strongly consider, and in fact recommend, having a pre-suit mediation provision in your contracts. Well, what about before we get to a pre-suit mediation? They've got to put you on notice of a potential claim, right? The South Carolina law requires, under the Right to Cure statute, that these homeowners put you on notice of what the alleged defects are and give you an opportunity to inspect, remedy, or settle. Now, in reality, I will be very candid with you. The South Carolina Right to Cure statute has absolutely no teeth whatsoever. It's unfortunate, but it gives you 2 opportunities. One, first and foremost, you win this first, you put it third. You put your trades on notice. You put your carrier on notice. Why is that? If you have contracts with your trades, which you should, and they have additional insured provisions, which they should, and they have indemnity provisions, which they should, if you have all of that, put them on notice immediately, because what you're doing is you're protecting yourself for any costs that you incur from that point forward, and you're able to get those reimbursed by those AI carriers, or alternatively through the indemnity provisions against those trades. So what you need to do is say, hey, this isn't a formal claim against those trades, but you're putting them on notice saying, hey, we are on notice of a potential claim related to your scope of work. We recommend and suggest and require that you get out there too. Let's go take a look. Now, it's also important because this is your first opportunity to take a look and inspect the conditions to see whether or not you agree that they're defective, right? So get an engineer, bring them out on site, and take a look to document those conditions, because that will help you prepare for what? That pre-suit mediation, right? Or even arbitration or litigation, whatever you decide. But this is your first opportunity to inspect and to document. All right, we're coming full circle because now this is back on you as the builders. But this is true. So most often what we see are small warranty claims that lend themselves to this snowball effect, right? Okay, hey, I've got one leaky window. Well, okay, listen, that's not covered under the warranty. You know, the warranty company denies it, the home builder denies it. So what do? They go talk with an attorney. They say, hey, I've got this one leaky window. What do you think is going to happen? That attorney is going to say, I got you. I got an engineer. And there are a handful of engineers that we see who do this on a daily basis, but I can guarantee you I've read their reports and I could draft them with my eyes closed. They're going to say, hey, you've got flashing issues with all windows, not that just that one, right? There's no way you just made one mistake. It's all windows, so they all need to be removed and replaced. Oh, but guess what? You've also got issues with your roof. That needs to be removed and replaced. And your siding, absolute shit, got to be removed and replaced. And that's what you see is full strip and reclads when you have one leaky window. And they do that, why? One, I'll tell you, because those attorneys want to get paid, right? If you see some of these jury verdicts that have come back recently, it's not to repair the conditions of those buildings, but what they do is they fabricate and embellish these repair scopes and the costs, right? So that ultimately at the end of the day, they can, get that one window fixed. That's what they want to do. But then they're making sure that the homeowners are protected and that those attorneys are protected. So I tell you that because when you get these warranty claims that may not be covered, and you know what? That's fine. There's a lot of claims that aren't covered. But do consider performing repairs for claims that are not covered warranty claims and getting a release for that issue, because that's one less concern that that homeowner has, and you've resolved it so that therefore in the future that will not be a part of any pending lawsuit. But in reality, this is where it starts. It starts with you servicing your clients. I talked earlier about your contracts with your trades, and your contracts with your owners are important, without a doubt. I mean, that's where it's where you make your money. But your contracts with your trades are equally, if not more important, and I'll tell you why. Because again, I referenced earlier how many builders don't actually perform any work. But at the end of the day, you're the general contractor. This is your project. You're going to be held completely responsible. Then the issue is, okay, am I able to offset that exposure from my contracts through with my trades? And so you've got to make sure that you have strong indemnity provisions. And Ron, I'm sure we'll talk about this, but it's got to comply with the anti-indemnity statute. Meaning you can't have this overarching indemnity provision that says, I want you to indemnify me for any claim that may arise out of your work. Well, that sounds great, right? Oh, anything related to your work? Yeah, you're going to cover me for it. It doesn't work that way. So you've got to make sure that your contracts comply with the anti-indemnity statute. Now, this is critical to make sure that you have contractual indemnity claims. You hear about equitable indemnity. If you don't have a contract, or if your contract doesn't comply with the statute, you're left with an equitable indemnity claim, and all they have to do is show that you are 1% at fault for that condition. Whether it's any oversight and supervision or management or a product installation that was picked, anything. And as a builder, they're going to be able to find 1%. All right, so you've got indemnity as a critical thing that you need to include in your contracts with your trades. Insurance. So I see this frequently with builders, is they will reference an exhibit saying, hey, I need you to have certain insurance requirements through your general liability and also your additional insured. Well, the problem is this exhibit oftentimes isn't attached to the contract. Well, no carrier is going to agree to pick up the defense if you don't actually have that language as part of the contract. Put it in the contract. Now, the additional insured, I cannot stress enough, make sure that you have additional insured insurance. Without a doubt, this is critical. And again, we talked about the right to cure. You put your trades on notice because you're going to also tender to their carriers to make sure that you've got additional insured insurance. We want as many pockets of insurance protecting you as possible, right? Your one general liability policy may be great. Let's say you've got $1 million limit. Well, what if it's a $5 million claim? Well, do you have an umbrella policy? Well, good if you do, but what if you don't? Well, then you're left with $4 million shortage. Well, then you're going to say, hey, trades, really need your help. And ultimately, you need to be looking to them on the front end to cover those damages and then use your policy on the back end. But additional insured is critical. And also, I don't know if you all can see this, but down on the bottom, but that says COI means nothing. That's a certificate of insurance. It means absolutely nothing. It is not worth the paper that it's written on. It will say this, you know, hey, I've got this insurance for as a trade, this carrier, these limits. It means nothing. I've seen it where you call the broker and they're like, you know what, they cancel it the next day. Or, no, they didn't get that endorsement. Well, I've got this paper. It says it. Well, it doesn't mean anything. And in fact, if you read the certificate of insurance, it says that specifically, that it doesn't convey any coverage. All right. Now, we've talked about indemnity. We've talked about the insurance. There's also the warranty provisions that you have with your trades, and this is critical because you want to, again, we talked about this earlier, make sure that you have strong relationships with your trades. You communicate with them, and also this goes to servicing your clients, right? You work with your trades to get out when there is a warranty claim. They make those repairs. Listen, if it's an issue with roofing and they didn't put in a starter strip or they didn't put in the correct number of fasteners, whatever it may be, you need to look to the roofer to come back out and fix their work. Oftentimes I hear builders say, oh yeah, well I paid them to come back and do it, because it was warranty work. Well, if it's warranty work that was deficient work, from my perspective, you shouldn't be paying them. They need to fix their own work. So make sure that you have in your contract a provision that requires them to come back and make sure that they then perform warranty work in accordance with your agreement with your owners. Now, if you do all of that, remember that's at the end of the day, let's send them back into the cornfields, right? So communicate, service, build a quality home. It all starts with you guys, right? But after that, we're here to protect you, whether it's contracts, warranties, or insurance. And Charles is going to talk about warranty or insurance right now, and then we'll have Ann finish us off. And then, thank you. Happy to talk about any questions at the end or now, but want to make sure that we answer anything that y'all do have, okay?
Great job.
Okay. Bear with me. Okay, good. Toys work and everything. Most important part of a home, in my opinion, is the foundation. If the foundation's not right, everything falls apart from there. What Taylor has just laid out for you is the foundation for being successfully defended and protected. Again, Ron's teaching at 2:30, I believe, Ron? Yep. Strongly recommend you going. I'm not an attorney, I don't play one on TV, but I know if it's not in writing, it doesn't exist. And if it is in writing, you need to make sure you do what your contract says you do. That can be some things as simple as change orders. I've seen it where it says change order be signed by both parties. Do you do that? So the long and short of it, particularly on the insurance side, if you're not going to do it, don't put it in there. But you may have picked up on a trend, you need to contract with your subcontractors. Every one of them, you need it. General liability, most people don't know what it actually covers, and a lot of times you don't find out until the wrong time. So we're going to touch on general liability itself, the coverage endorsements and exclusions, and then again, as Taylor mentioned, additional insureds. And if y'all have a question while we're going through this, feel free to stop me, or we can answer any questions at the end as well. First thing I will tell you on a general liability policy, if you see anywhere on the declarations page that says taxes and fees, throw it in the trash. It is not worth the paper it was printed on. And I will show you some, I'll find them shocking exclusions that are on those policies. Bodily injury and property damage, very simple. Someone gets hurt on the job, not an employer or sub. Homeowner, you're building a custom home. The husband is upstairs looking at his man cave. The wife is either working on the kitchen or her master bath, her dream bath. The kids are at Disney. They are on a job site. There are so many things for them to do and nobody's watching. Someone gets hurt, the general liability will step in. That's a very simple portion of it. The property damage, house is not wired properly, causes a fire, it's going to pay for the home, it will pay for the contents and their additional living expenses, and God forbid anyone be hurt. So Resulting damage, this is where this comes in, particularly for the builders. Resulting damage from poor work. Again, like I said, it can be electrical, it can be a roof that leaks and causes water to pour in. It's always over a closet for some reason. It is over the master closet, every leak I've ever seen. But it's going to cover basically the cost to replace and repair those. One thing that a lot of people get confused about is they think it's prepaid legal. Yeah, homeowner and I have gotten into a dispute, they owe me money and they won't pay the rest of it until I fix these items. There has been nothing to trigger the coverage. There's been no bodily injury. There's been no property damage. Yes, you may be potentially out some money, but that doesn't trigger the general liability. So that's one of the biggest things that people don't always understand. It's not always going to fix everything. Touch on a few when Taylor's talking about limits of liability. First one, a per location or a per project aggregate. Most policies you'll see have $1 million per occurrence, a $2 million aggregate, or a $3 million aggregate. Per occurrence is the most they'll pay for any one claim, any one instance. The aggregate is the most they'll pay during a policy period. And typically you can get a per project or per project or per location aggregate. Most are about $500. And it basically takes that $2 or $3 million limit and has it at each project or each location. Something to really look into. Is strongly recommended to do that. Blanket additional insured is another that usually if you're building custom homes, most homeowners will require that they're listed as additional insured. Usually you're faced with about $100 per owner. You can typically get a blanket additional insured for $500. Just depends on how many homes you do, if you're doing more customer spec. And some coverage extensions and enhancements you may want. Cyber is a big issue these days. And we have a seminar here at this convention as well that you'll be able to access online. Those are the good ones. These are the ones that basically broaden coverage and are in your favor. And now gets to the frustrating part. There are a lot of people in y'all's industry that shouldn't be building. There are a lot of people in our industry that shouldn't be writing home builders. You would be amazed at the number of people when we go in and sit down with them. So basically we get the information and it's like, and I need to see your current policy. And they say, well, if you see my current policy, you'll know what I'm paying. I'm like, look, I'm gonna know what you're paying anyway. I can quote, Hunter and I can do it. You sit there with a laptop, I can quote at your location, turn the screen around and show you, and then compare it to your current coverage. One of the big ones that came in about 15 years ago is CG 2294 or CG 2295. The exclusion, the way that this amends it, the original exclusion L in the general liability policy says does not cover property damage to your work arising out of it or any part of it, and includes the completed operations hazard. The general liability policy unendorsed says unless performed by a subcontractor. This goes in and takes out those words. And it is a critical difference because that takes, if it's done by a subcontractor, and most builders do a large portion, if not 100%, subcontracted work. And you're probably sitting there going, well, that just makes this policy not worth crap, and you're right. I also will tell you that one of the first things we do when we meet with a new client is say, look, if you don't give me a set of house plans and ask me to do a takeoff, I won't give you an insurance policy and ask you to translate it. And we usually get along pretty well that way. Oh, it's gonna be a little fuzzy. It's funny, Taylor and I were having breakfast this morning, and he said, I had one of those WTF moments. So one of my associates called and said, we tendered the claim to the client, to the subcontractor's insurance, and they came back, so we need all the subcontractors' agreements, we need all the certificates. And they said, yeah, well, actually everything you need's right there. And they said, nope, if we don't have all that, and looking at this, you've got to have written contracts with each sub, obtain a certificate of insurance of at least $1 million per occurrence, workers' comp. This one actually goes into workers' comp. This is general liability saying you've got to have proof of workers' comp if it's applicable in this state. Proof that the contractor has a license active and in good standing. And by the way, these are all ands. These are not ors. These are all and. That's one of the important things. I'm not an attorney, but I do know that when you see and, this whole thing strings together. Maintain the records for 10 years. Isn't that great? If these records are not maintained or you otherwise are unable to establish the existence of such agreements and certificates of insurance, we shall have no duty to investigate, adjust, or defend with respect to a claim or suit seeking damages. And then, just in case you get through that and get all around it, we'll take your $1 million limit and you now have 25,000. So if somehow you get around all those other obstacles, we're still only going to pay 25,000. That was the one that literally this morning at breakfast we were talking about, and I said, I've got it actually in my presentation. You would be stunned the number of people that don't know that this is in there. Contractors that aren't using contracts, you ask them, then you get some of them. Had one say, well, I get it from the big guys, the framer, the electrician. I don't worry about my landscapers and the other guys. We have a builder in the upstate who is not here, thankfully, so I can use this example. The day before the CO was issued, $1 million home. Everybody goes to lunch. They come back to a 4-alarm fire. The landscaper had a load of mulch delivered. They dumped it. Unfortunately, they dumped it right up against the deck. It was July. It was hot. Came back, spontaneously combusted, went right up the deck, burned the house to the ground for $1 million. So this is one, again, you're starting to see a lot of tract home limitations. This particular one says that tract home means a grouping of 20 or more single-family dwellings. We've seen that as small as 5. So again, you'll need to read the policy terms if you have a question.
And that could be a neighborhood. Just,
Yeah. Oh, these are great. This is the fun one. Prior work exclusion. You'll see a number of these that say we don't cover any work that happened prior to the start of this policy. That sounds great, and you kind of almost see their side saying, well, I don't want to pick up anybody else's thing, except South Carolina's a continuous trigger state. I believe we're one of 13, Ron or Taylor, in the country, in U.S. We're one of 13 states. It's a continuous trigger. Basically what that says is typically it's water. From the date of the CO to the date it manifests itself, every day was an occurrence. You don't know if it actually rained that day or it didn't. You don't know if the rock continued that day or it didn't. So they said, we'll just do this the easy way. Here it is. If you have this, again, on a policy, you're now not matching up, your coverage is not matching up to the way the state law is interpreted. Classification limitation is another that you will see often. Says if it's not a classification listed on this policy, then it's not covered. Where that can get you is if you happen to have an uninsured subcontractor. If your policy has superintendent's class code and subcontractor work, but not anything else, this gives them another way to get out of it. Much like the prior work exclusion, I'll go through a couple of these. This is actually the wording of the prior work, and they're going to have a date on there, which is typically the effective date of that policy. But they're basically getting rid of anything that happened prior to this policy. Coverage under this contract is specifically limited to those classification codes listed in the policy. No coverage is provided for any classification code or operation performed by any insured not specifically listed in the coverage part of this policy. And the last one here again, we are a continuous trigger state. That's why I said if you see taxes or fees on your policy, just throw it in the trash.
do you have an example of a COI that might show that?
Okay, even better question. The COI is not going to show that. That's something that would have to be addressed in the contract with the subcontractor. Yeah, that typically you're not going to see on a COI. Actually, you're not going to see it on a COI. Taylor touched on additional insureds, and I've seen presentations where people get really deep into the different forms that you can use. Most of our work, you've got the pearly gates and you've got the eternal fires. The pearly gates, you have fantastic contract, you've got additional insured under Form 2010, 2037, waiver of subrogation, boom, I mean, you've got it all. That's up to the pearly gates. Eternal fires, you put a mirror under the guy's nose. If it fogs up, get him to frame the house. So we try to be somewhere in the middle. Typically, the pearly gates is going to cost you a full-time employee. And when we mentioned earlier, we were talking about the contracts. I've seen a number of subcontract agreements where they've got these forms. So many times, the person in the office is keeping the certificates. You say, "Are y'all additional insured?" Say, "Yep, it's right down there at the bottom." Like, that's the certificate holder. They can put your name in the description of operations. There's a cute little box they can check up by the general liability for additional insured. It is critical that you do that. The biggest trigger, the best way I know to explain it is if you and the subcontractor no longer are doing business, and sometimes that happens in your trades, that you will have a falling out. The additional insured gives you the ability to file a claim. Y'all correct me if I'm wrong, but basically you have insured policyholder rights that you can file a claim, because a lot of times the subcontractor will ghost you. He will not accept mail. You're stuck. If you're not an additional insured, most of the subcontractor carriers say, "This is a policy between XYZ Plumbing and Hartford Insurance. You're not a party to this contract." So the additional insured removes that. I do not get deep in the weeds on the different variety of additional insured endorsements. I would recommend, if you don't have a contract, get with one of these gentlemen. If you do have a contract, read it and be sure that you're following what it says. If it lists specific forms and endorsements, you need to, and have any questions, get a copy of it and give it to your broker and have them look at it and explain to you if this matches your contract or not. You'll see a great deal of the blanket or custom forms from carriers. There again, you need to have your broker look at it to see if you're actually covered. Many of the additional insured wordings or verbiage you will see on a certificate says, certificate holder is listed as additional insured if required by written contract. So are y'all noticing a trend with this? So the contract, if you don't have a contract with them, it says you're additional insured, but not really. And the other thing, as Taylor mentioned, certificates are great to have to show the auditor. They really do not hold a lot of water. It's a snapshot of that builder or that client, subcontractor's coverage at that moment. Once you're a certificate holder, they don't tell you if the subcontractor has two $500,000 claims and no longer has coverage, it's already worn out. It doesn't tell you the limitations on it. And unfortunately, most insureds, once you cancel the policy, most agents aren't going to take the time. They've already lost money. They're not going to send a notification to you. You should get notified, but that typically does not happen, particularly if it's an agent that really doesn't know what they're doing. Brings us to claims. If you build it, they will come. A claim is not necessarily a bad thing in our industry. To me, it's an opportunity for you to show how good you are. I sometimes feel like a farmer's commercial. I really wish I did not have an example to give you, but the perfect example, we have a builder at the beach whose painter decided he would spray the exterior, and 3 of the neighbors' houses and cars. The first 2 were great. They were easy going. We're going to pressure wash your house. We're going to get your cars detailed. Everything was beautiful. The 3rd house, my builder said, if we put a pressure washer on that siding, the house would fall down. That was also the guy that wanted $25,000 and then went to Dewey, Cheatham and Howe and filed a suit. And so our client is like, great, we've got a contract, we've got the certificate, we filed the claim with their insurance carrier, who had an overspray exclusion on the policy for a painter. So from that, you can do all you want unless you're going to hire someone full-time in your office to get certificates, to get a copy of the subcontractor's policy, get your contracts, have them in place, make sure you've got the proper insurance. But for our client, it's an opportunity to show we've got everything together. We've got the inspection reports, we've got written contracts, we've got everything. We tried to do everything we could. Sometimes things like that are going to happen.
Okay. industry leader. 1 in 5 new homes has a 210 warranty, which is really impressive. If you think about all the national builders, but 1 in 5 new homes in the country has a 210 warranty. Our mission is to improve the quality of housing and the experience of home ownership. So we'll kind of talk about valuing people, pursuing excellence, and really protecting the builder's profit. This, again, protect your profit, promote your quality, plan for your future, and partnering with the industry leader. Just kind of helps with a lot of things that we will go over and talk about. So things happen, right? Like people make mistakes, like there's things that just doesn't make sense. I mean, you can't be at your job site all the time watching, all the subs there constantly. So bad things do happen. So is it better to have an implied versus a written warranty, right? It's much better to have everything in writing that clearly defines what you're responsible for. So we'll kind of go over about the standards and how that does limit your liability and protect you as the builder. So that's our actual warranty document. We also have the maintenance manual, and then the service agreement is kind of what people think of like a warranty. They're like, oh, you're going to go back and do it. I'm like, no, we're not going to go back. This is your warranty contract with the homeowner. The service agreement is what we would go back and do. You pay the $75 or whatever, right, on your appliances and stuff. Our warranty document is more risk management for the builders. Again, to put everything in writing and define their legal liability. So it's 1 year workmanship, 2 year distribution of systems. What's behind the wall? That really is blinding. And then the 10 years of structural. And I always get this question, what are you going to do? Are you going to do the 1 year? No, that is your responsibility as the builder. The only thing we're going to go back and pay is for a 10-year structural defect and the resulting damage. So heaven forbid, like in 2008, we were responsible when the builders, won the lottery, moved to Costa Rica. We were responsible for the 1 and 2 year. So because that is insurance-backed surety coverage for the builder. So the builder does have to be approved with good credit, years of experience, and like no liens and stuff. So it does help promote their quality, right? Any questions on that? I'm kind of talking fast. Okay. I love that they mentioned about, the right to repair, replace, and a release form. I've got so many builders, they're like, no, we want to go back in after the arbitration. I'm like, oh, do you really? You and the homeowner have not been seeing eye to eye. They already don't like you. You need to talk to your attorney and get a release, and especially if you're going to do the work. But better yet, I had one recently, and we're like, just write them a check. Just write them a check. Don't go back in there. They're not happy. But having the construction standards, which again, it says what's excluded, what the builder's responsible for, it just really helps clearly define versus not having anything in writing. Because even though I grew up in construction, that doesn't mean that I know, the nail pop and this is supposed to be 6 feet normal lighting. Everybody thinks their uncle's dad's a builder and it should be this way. So by having the set guidelines really helps eliminate some frivolous things. This is our Frontline program, which I just absolutely love because it does document everything for the homeowner and builder. So the homeowner submits their warranty request through the homeowner portal, and then our team responds back with the construction standard for each item or if it's excluded. So we keep that for 10 years. So to have everything tracked and documented, even if the homeowner sells the home in 6 months or a year or 2 years, we can run a report and have everything, pictures, everything that was submitted. And again, the warranty document's great. We all know they're not going to read it, right? But when they submit their warranty requests, whether it's nail pots, whatever, then they're going to kind of look at this, right? Because it's for each item they submitted. So it really helps educate and set the homeowner expectations for the builder. It's been huge for a lot of my builders. Even my really high-end custom builders use it. Again, if it's expired or if it's excluded, again, just to have it tracked and documented, because it's somebody else telling the homeowner, hey, this is the standard, this is excluded, I'm sorry, you're out of your 1 year. So it really just helps kind of take it off the builder, because they're going to be mad at the builder, when they're not getting things done. Like Taylor mentioned, it's so important to communicate with them. And I tell the builders, they're like, they're still calling me, this is a $5 million house. I'm like, they have to submit it through the homeowner portal for quality control. So you can track it, you can do reports on your subs to see trending defects. So it just makes it for a set process. And it makes us look like the bad guy, and then you can be the hero if you want to go back and do it. This is kind of a snapshot of the portal to where, we defer a lot of depending on what the builder wants, if they want them deferred until like the 11th month, instead, because the builder only has to go back there one time for nail pops and things like that. And then you can see at the bottom it is fuzzy, but that's where you can do a trending defect report, open, close warranty request. So, and a lot of the builders will say, okay, if this isn't closed out in 30 days, we want to know about it, let us know. And then they even send the homeowner like a completion, but you can email this to the sub too, and that way it's all tracked that you did send it to the sub, and the sub can do status updates as well if it's completed and things like that. Again, it's all about whoever has the most documentation and everything in writing wins at court, right? Any questions on that? Not everybody at once. Very exciting stuff. So this is where once the builder does in the status update, hey, this is completed, then we do send them a completed, or if we're like, hey, this has been open for 30 or 40 days, we check in with the builder and let them know you might want to follow up with the homeowner, like even if you're waiting on the drywall guy, whatever, just again, so it's all documented and tracked, because when you're not communicating with the homeowner, that's when they get mad. And when I started, again, when I was 12, there was 18 attorneys to every one home builder. Do you remember that was like an ad for NAHB? And now I'm sure there's a lot more. So when you do find the good attorneys like Ron and Taylor, it's very important to use them. Structural defects, people are like, that's not going to happen to me. I have an engineer. Well, most structural defects come from soil settlement, not builder error. So it's very important to get your compaction test. I had one in Charleston recently. It was like $242,000. The house was only 3 years old. And of course, it was during Christmas and we had to move them out. So that was awesome. And it's not a pretty, you know what I mean? Fixing a structural defect, it's not pretty. I did have other pictures about it, but yeah, all your neighbors are gonna talk about it. So it's better to say, look, we gave them a 10-year structural warranty from 210. Their people are handling it, versus it kind of being on the builder. I mean, literally, a structural defect, average cost is between $45,000 to $50,000. I mean, you could, instead of that, you could have a boat, or you could have a truck, and the warranty average, depending on the final sales price of the home, is around $700. Same thing with this. I mean, it's cheaper than your front door, and I'm not sure how much your, front door is limiting your liability, but we have claims and warranty administration. For a lot of our builders, we do dispute avoidance training to let them know, let us know when the homeowners are mad at you. We have warranty administration that will talk the homeowners off the ledge a lot of times, because when they're already so mad and they're getting an attorney, it's like, we can't really talk them off the ledge anymore. And a lot of times it's other things that's going on with them and they just don't want to deal with the builder on it. Our arbitration, claims administration, builder resources. You brought up about arbitration in AAA. Ours, which I think is really great, it does say in here, and it does happen at the house, but it's construction dispute resolution services, or DMAR. So it's people that actually know about construction versus just AAA, because they really have not that much clue. But at least they're going by the warranty document. Any questions on that? When do you want to sign up? Right, Quentin?
Right.
Right. It's amazing.